Richard Stobbe. I'm going to start out with the review of intellectual property law, because I think that sort of lays the foundation for the whole discussion. Go through some issues relating to licensing, litigation, which is the fun part, and then I'll throw it open for questions. First category we'll look at is trademarks. Now, trademarks protects brand names and logos and words that are used in connection with the sale of a product or a service. Okay, so you think of the Nike swoosh or the word Nike as a trademark. Copyright is really central to what you guys do, and that protects traditionally things like books and paintings and photographs. Now protects the layout of websites as well as code, games, and software. Patents protect inventions. You think of a device or a mechanical device or a chemical composition or a formula or a way of doing things. There are a few other categories of intellectual property which I won't go into a whole lot of detail, but one of them is trade secrets, which covers basically the secret recipe. You think of the Coca-Cola recipe would be a trade secret of a company that gives them value or gives their product some value because nobody else knows it. And then there are other categories of protection such as industrial design, and that we won't go into a whole lot of detail. But that sort of gives you some ideas on the broad categories. Now here's an example of how these things might play out in the real world. So we've got the trademark of the provider of the handset. Okay, so they've got their brand name on the device. And the service provider, so it's a Rogers or a Telus or whatever, they're going to have their brand name or their trademark on the device being sold. And there's going to be trademarks of the companies that are providing services through the device, or apps that are sitting on the device. They may have their own trademarks and their own brand names associated with those products. And there's going to be proprietary software that may run a camera or may run some underlying hardware component that's sitting on the device. So copyright would protect the software. There's going to be copyright in apps that may sit on the device. That would be protected by the law of copyright. And there's going to be copyright in the software that runs the device. And even though it's an open source software application, it's still protected by copyright. It falls into that category in terms of the legal elements of copyright or intellectual property. Okay, so then there may be trade secrets in the background for the companies that are selling the device or marketing it in terms of how they're going to make money off this thing, what their advertising methods are, and so on. And the one thing that's not mentioned here is industrial design. Industrial design would actually protect the shape of the handset. Okay, so companies like BlackBerry or Apple will register industrial design for the shape of the device. Lego is actually originally protected by patent. Patent only lasts 20 years, so the patent has expired on the Lego blocks. So they protect it now completely through the world of trademark. Okay. Now they tried to trademark the shape of the blocks, the little round. They actually were protecting the unique sort of shape of what, there's a special name for them. They had them in litigation, but anyway, there's a big lawsuit over this, and eventually Mega Bloks challenged this, and the court said, no, you can't protect something through trademark that's functional, and the little round knobby things on the top of the brick are functional because they hold the bricks together. So they lost the trademark on the shape of the product, and so they have to protect it through sort of brand extensions and other trademark. Other elements of trademark. So you guys know what open source software, I won't go into that in great detail. I had to explain to lawyers what this was all about, and they had a hard time wrapping their heads. They said, no, it's not like free beer, it's like free speech, and they had to I had to educate them on what this all means. Essentially, an open source license is a set of terms under which you provide something, in this case software, to others. So it's no different in a theoretical way from the closed version of a license that Microsoft will make you sign or make you agree to when you download software, or Apple makes you agree to when you download their software. It's a contractual relationship that you're agreeing to when you download open source software to agree to a certain set of terms. And as a provider of software, if you release your code under open source license terms, you're asking others to agree to that set of terms. You're entering into a legal relationship with others through that license. In the open source community, it seems like copyright is a bad thing. It's a four-letter word, and I'm here to tell you copyright is your friend. Okay? Don't be angry with copyright anymore. I want you to go out and buy copyrighted beer tonight and say, I'm sorry I was so angry with you. This is sort of my pitch on what the role of copyright is. Copyright, just so you have an idea of what it is. As I said, it protects software and images, that sort of thing. It exists, it springs into existence automatically when you author something original. Okay, so as soon as you write something, even the notes you're taking or the code you're creating or a photograph that you're creating, as soon as it's created and it's original and you're the author, copyright exists. Okay, so you don't have to go out and get copyright any more than you have to go out and get human rights and say, oh, I forgot to get human righted, last night, so I don't have any human rights. Well, those things just exist. Okay, copyright is similar. Copyright just exists by virtue of the Copyright Act. Okay, so as soon as you create something, copyright exists. I prefer to talk about protecting things through copyright rather than copywriting something, because copywriting something creates confusion with the task of writing ad copy or writing copy for your marketing materials. So copyright exists by virtue of the Copyright Act. It can be registered, so you can go off to the Intellectual Property Office in Ottawa and pay your $50 and you can register copyright in connection with your work, whether it's software, image, whatever. But you don't need to register it in order to enjoy the rights associated with copyright, okay? Because as I said, copyright just springs into existence. So you can register it, it's cheap and easy, relatively speaking, and the benefits are that you've got a presumption that you own that work for which you've registered copyright. The author owns what they create, okay? So as soon as you create something, you're the author, you own it. The length of copyright protection lasts for the life of the author plus 50 years. That's the current state of the law. Now the one caveat there is that if you're working for an employer, what the employee creates is owned by the employer. Okay, so there's a distinction there to be made between an employer, an employee relationship, and a contractor, an independent contractor who's not an employee. You've got a company and you've got employees, whatever they create is owned by your company, by you as the employer. But if you're hiring independent contractors to create something for you, they own that. That's sort of the default, unless there's an agreement in writing to the contrary. So that's important because if you're delivering code to a customer of your own, let's say you're creating a project, writing a bunch of code to create something, and you want to deliver that package to your customer, you want to make sure that all those contractors who are creating stuff have assigned that over to you, so you've got a package that you can deliver under whatever deal you've got with your own customer. Okay, so you've got to get an agreement signed in writing. Yeah.
How does that apply to an entire project? Like, let's say you take some massive component and you are hired to extend one little piece of it.
Yeah.
Say, for example, current, right? You're hired to break a module. Naturally, the original work on the module itself would be copyright for company or you personally or whatnot, because you might be at the top of the file. But what if you extend another company's work? Like, say you fix a problem in something else already copyrighted by Intel or Novell or something like that.
Right. Well, if you're creating a module that sort of bolts onto another copyright application, or another software application, you can own the copyright in that module, and you would, that's quite common through, customizing through the APIs. You're creating something that fits a particular customer. Yeah.
Well, if you're adding on to an existing one that already has a copyright?
Well, it depends whether. It depends on the terms under which, because do you own, or are you doing the work for someone else in this example?
I'm doing the work for someone else.
Okay, so let's say someone comes to you and says, we got this module and we want you to improve it somehow.
They don't say that. I found that I need to extend another module.
Okay.
So the other company has no knowledge of it whatsoever.
Right.
Am I allowed to do that?
Well, it would depend on there's going to be license terms attached to that module somehow, right?
Let's assume GPL.
Okay, so the GPL, then you have the right to modify it and improve on it. And if it's published, then you have to share the code or make the code available.
Of course.
Yeah.
He's sort of assuming responsibility for creating the GPL by virtue of being threatened to do this work by his employer. And so you've got a guy at the law who has somehow involved a giant corporation, legal responsibility, maybe without much knowing about it. What's happening?
Well, the company would, if it's an employer, it's a company that has the obligation. I mean, the company is supposed to direct its employees to sort of not breach agreements that the company's agreed to. And the GPL would be an agreement that the company has agreed to if it's using a certain module. I mean, in terms of your ability to modify it and tinker with it, if it's under the GPL, by all means. And then it becomes more a question of, do you have to disclose the code or not? And if it's...
Who owns the copyright? Like, knowing an entire file is easy enough, but having a specific subroutine, specific comment, or whatnot, on an individual basis. Like, in the past, from what I've seen other people do is, let's say, Novell writes one module, Intel extends it. Intel would add on whoever added work at the top of the file saying copyright 2010 Intel, and someone from Red Hat extends it, and they just add their names to the top of the file.
Yeah.
Is that all you need to do?
Well, if it's GPL, then yeah, you need to include all those attributions. And if you're creating new code, you know, you can release it and say, well, I want my name, my own attribution for the employer or whatever, to be included. And so it's a form of contract, and it has to sort of match up with all these legal concepts of contract law and intellectual property law and copyright in order to be enforceable. And you want it to be enforceable because if you want your code to be released under certain terms and be shared and whatever, you need to make sure that it fits into the system we've established. Okay, so and enforcement may be required. That's the other sort of corollary, which I'll talk about in a bit. Okay, so I'm going to quickly talk about trademarks. These are all trademarks of open source, either companies that are using open source or selling products. So trademarks are about brand identity, and they can be used in connection with the sale of a product or service that's based on an open source software application or system. So the previous speaker was talking about iOS. I mean, that is a trademark of the company that's providing that service. There's a question then of what's their business model. Someone asked the question, how are they making money? But they have the right to own the trademark, to register the trademark if they choose, and to control the use of the trademark. So it's a completely different creature from the copyright or the software. And again, enforcement, in theory, may be required to protect those rights. Quickly talk about patent law. As I say, patents protect a method of doing something. They can protect a method of doing something. And there's a debate now in the famous software patent is the Amazon one-click patent, where they ran out and grabbed this patent on the method of doing a checkout from a shopping cart online using one click. And everyone said, come on, I mean, that shouldn't be patentable because it's obvious or it's been done before or whatever. So in Canada, they actually denied the Amazon one-click patent, said, no, that's not patentable. It doesn't meet the criteria of patentability, and Amazon is appealing that. And in the U.S., it was that particular patent was re-examined, but they're under review in both Canada and the U.S. And there's a decision which is filtered up to the Supreme Court in the U.S., which has been heard, and the decision is expected sometime this year, which hopefully will provide some clarity. So that's sort of on the radar in terms of how this will all play out in the future. Whether business methods and software is patentable or not, and if so, how. But in the meantime, many companies are using patents as a strategic tool in their company, in their business. So Red Hat is the classic example where they've got a patent portfolio that went off to the patent office, patented a whole bunch of inventions in the software arena, and they said, hey, we're not going to use this to pound other people on the head and put them out of business, but if someone tries to do that to us, then we've got our patent portfolio in our back pocket that we can use as a shield. So I'm going to go through this more quickly, unless you want me to dwell on it in more detail. But basically, there's the idea that some open source software license terms will permit you to license on both proprietary code that you've created, plus the open source code from which you've derived your proprietary code, and license it on. However, the GPL and other what might be called viral licenses or reciprocal licenses are clear that if you have a commingled code that you've created from the open source kernel and you want to license that onward, you have to make available both your code that you've authored, in which you own the copyright, plus the original code that was the open source kernel that you received. Now that's the case if it's published, okay? And it says, I think the GPL 3 talks about conveying, but I think this is GPL version 2, but I'll have to double check the language. Anyway, it talks about distributing or publishing. So if you distribute or publish it, that's when the obligation kicks in under the GPL to make your own code available. Okay, so if you're using it internally inside your company or inside the comfort and privacy of your own home, then you don't have to make the code available if you don't want to. Yeah.
Is there well, I guess it's difficult, but if let's say I'm a head office in Canada and I'm distributing software to my subsidiary office in the U.S., separate legal entities,
right.
Is that going to be publishing?
Well, that is a very good question.
Or if I've got sister companies that are separate legal entities, is that publishing? Or if I've got a 1,500 person?
It depends what answer you want your lawyer to give you. So if you say...
Well, I don't usually want any lawyers to give you conservative answers.
Yeah, so if you say, we don't want to make our open source code, or our code open because it may benefit our competitors, then your in-house lawyer is going to say, don't worry about it. It's all in the family, and it's not considered publishing, even though there's no real definition of what it means to publish, because it's not made available to the public in general.
Is there any case precedents or anything?
I don't think there's any cases considering that particular point. There are very few open source cases. One always hopes for more litigation, but we must make do with what we have. That's right. We're impoverished in that way, but we'll carry on. But if you're the open source, you're the Free Software Foundation, you might say, hey, it's crossing and international boundaries to a separate legal entity. We consider that to be publishing, and let's see the code. I mean, 99 times out of 100, any kind of GPL violation is, because somebody out in the public has stumbled upon the code and realized that there's GPL terms attached to some kernel somewhere, and it's widely distributed code, so it's not within a company. So I think it's safe to say that if it's within a corporate group, that it wouldn't be considered to be published, unless you ask me to opine otherwise. Yeah.
Could you just also say, like, it's not the finished product, it's still a test version?
Okay.
Yeah, and then you will also go out of that, at least within the company, to say the product isn't finished, so it's still in development.
I don't think the GPL makes that distinction. Yeah.
You could say that, but I mean, you can certainly publish a beta version, and it wouldn't be considered not published just because it was beta. So I don't think that would be conclusive of it, but you could say that, yeah, you could use that as one of your arguments. Okay, so yeah, that's just more about so the non-viral, non-reciprocal license talks about redistribution and use of the code with or without modification. So then that's permitted. So there are licenses which permit you to license onward the application, keeping your code closed, and the original open source kernel would be licensed onward under the open source terms. Okay, now I'm going to talk about some risks and opportunities, and we'll throw it open for questions. Now, this comes from my experience working with a lot of companies who are software developers and are proprietary, or who license proprietary software, and I act for a number of developers who are work with open source code. So these are some of the concerns that you hear, I'm sure, in your own business, and they've got concerns that if there's any open source elements that they have to release their source code to the general public and thereby lose some advantage in the marketplace. They may be worried that they're going to lose trade secret information, and that their investors are going to get nervous. So these are all things that you need to be aware of if you're working in this area and you're working with companies who are selling proprietary code. So what do you need to look at? Well, the use being made of the code, which you talked about, is it internal or is it being commercialized and licensed out? The license terms. Now this is an important one because there are dozens of open source license terms. There's more than you can count, and And you could come up with your own. There's no reason why you couldn't take a set of open source license terms and start to tinker with it and say, well, I'm going to add this clause here and add that clause there, and modify it, create your own version of an open source license. None of these things are set in stone. They're just contracts that can be customized or modified or changed. So you have to look at the particular terms, that it's not a one-size-fits-all kind of proposition. And of course, depending on the type of license and the type of coding that's going on, how much enmeshing or commingling is happening in the different, among the code and libraries and so on. As I say, you have to determine which license applies. Due diligence on the code is my way of saying, well, if you are working on a project, you're going to have certain goals. You may want to launch the project as a proprietary piece of software. You may want to launch it as an open source project. That's not so important, as once you decide, then you got to go back and figure out what license terms, what the impact is of the license terms on your goals and what you want to do. And when you're doing projects for others, particularly for companies who are in sort of the closed proprietary category, and they ask you to code something and deliver it to them, they may ask you to make certain what are called representations and warranties, but basically promises. What promises are you going to make? Are you being asked to make about the code that you're delivering, about the project you're delivering? So they may say, well, we want you to promise that the code will function for 90 days, or will be bug-free, or will not have any open source software in it, or whatever. So whatever it is that you're being asked to provide, you have to look carefully at that and see whether you can actually make those promises, and if not, then you need to modify those. Or make promises about some things but not others. I mean, I have clients who I say, well, sure, you can make a promise, you can make all these promises about this code, but this other code that's open source or came in, we don't know what terms it was licensed under, and we can't track it, then you have to disclaim all your promises. Say, well, I don't know, this is as is, and I'm not making any promises about this. Yeah.
As a contractor, do you recommend people get liability insurance if you're asked to promise something that you're not 100% sure about?
Yeah, absolutely. I mean, there's ways to mitigate your risk. One of them certainly is insurance. Another way to mitigate your risk is to cap your liability and say, yes, I'm willing to make these promises, or I've been asked to make these promises, and as part of the deal, I have to in order to get the project. But I'm going to cap my liability. So in that contract, you say, well, my liability is limited to whatever number you can negotiate. Yeah, it could be the amount, it could be $10, it could be $100, it could be the amount that you're paid. You say, well, I'm not going to be on the hook for anything more than what I've earned under this project.
So maybe the amount that limitation would be 12 that flexible.
That's right. I mean, there's different ways to slice it. You could say, well, I'm willing to make all the promises you want, but the only thing I'm obliged to do at the end of the day if something goes wrong is either give you your money back, sort of a money back refund, or recode it at my own expense to make it comply with the promises you've given. So that there are different ways to manage the risk, but that's what it's all about. It is sort of risk mitigation. I mean, the other way to do it is to do it through a corporation, so that if all else fails, your corporation may go down in flames, but you're left standing and you haven't lost your house or your shirt. Yeah.
What would it take to take the copyright material offshore so that you protect it in another environment?
Okay, to enforce your copyright in another jurisdiction, say in Europe or in India or wherever. Is that your question?
Yes, if you take it to, let's say, Ireland, then you have a financial benefit as well, that you're not taxed on anything that's created.
Okay, right. So there, I mean, there's a couple of things. One of them is what are the tax advantages of different jurisdictions from a business perspective. So if it makes sense to set up in a certain country because of tax advantages, that there are ways to do that under tax laws and local sort of corporate laws and so on. But in terms of copyright, if you're a Canadian citizen and you're authoring something that's original is protected by copyright, then there are international treaties that protect the copyright in the countries who've signed on to that convention. So there's a Berne Convention which sort of covers all the countries who've signed on to this copyright law. So it should be protectable, your copyright should be protectable in other jurisdictions who've signed on to that convention. Now here are a couple examples, and I'll speed up a bit, but this is one where I call it a choose your own adventure license, where there's a set of terms. I just pulled this out of one that my client asked me about a few weeks ago. I said, what do I do with this? And I said, well, this is one of these multiple or dual licenses where there's a set of terms, and then it says, well, alternatively, you can pick this. You can choose what you want to do. And it took me a long while for me to wrap my head around this one as a lawyer, schooled in traditional licensing. But essentially what it is, you just pick the best one that works for you, and you go back to that idea of what are your goals and what do you want to do with the project, and what are you ultimately, what are you trying to achieve? And so which set of terms is the best for your goals? But what it can be useful for is ensuring that if your code is being released and you want, if people are going to take it into a closed environment, they're entitled to do that as long as they pay a fee, for example. Maybe that's your philosophy. But if they're going to share their code, then they're welcome to do that as long as then they'd fall into the GPL. So you can provide different license terms to your end users and let them pick one. I shudder to think what a judge would do with it if it ever got in front of the court. I don't know what they would do. They'd probably scratch their head and try to figure out what that means, because there has to be a certain amount of clarity in contractual relations. You have to be able to say, well, the parties agreed to do this. And if there are 3 sets of licenses, and it's sort of pick your own license, then there may be, the whole thing may fall apart. So I'm not sure what, ultimately, how that would be interpreted in court, but strategically, this is how it's been done, is to allow code developers to release their code under different set of terms for different purposes. And I mean, Microsoft and Apple, they do it for, they've got a student version of their software that releases students, and a commercial version and an enterprise version and so on. So it's not foreign to the software world, either closed or open. It's just, to my mind, it's a question of clarity. How clear is it that you've put a set of terms in front of your end user that they'll agree to? Well, that's right. You can negotiate something special if someone comes to you and says, well, we want to use it for this particular project, and we don't want the community license, we want something different. Then that's right. You can negotiate sort of a custom deal. Those custom deals are usually very unique, and there's not going to be a one-size-fits-all kind of proposition. Okay, here's a couple of examples. The Linksys is a fun one, just because, and you may have heard the story, but Cisco acquired Linksys for lots of money, and after closing, it was discovered, somewhere in the blogosphere, somebody stumbled upon this fact that there was this kernel of open source code that was subject to the GPL that was buried in this, I think it was a router. And so they were sort of shamed into releasing their code. And I say shamed because there was never any litigation. It was just sort of something that was exposed sort of online in the community, and eventually Cisco decided, all right, we'll release the code to avoid sort of bad press, and it's more of a soft or informal way of resolving the dispute with violation. Yeah.
If I'm using GPL code and I release my code to the public, the GPL part of the code has to be released as well. My code doesn't have to be done.
Well, depends what.
My code is modifying GPL.
That's right. That's right. So you can release your own code if it's not, as I was saying before, commingled or enmeshed in the way that is captured by the GPL. You could release your own code under certain any other terms, closed terms, open terms.
Some of the U.S. guidance was if you were like statically linking through a compiler, it didn't matter if you had separate source code files. If you're compiling it all together, it is a single thing, and the GPL would have to flow through. But if you released a DLL, or you released a product like there's a PDF writer, Ghost, that you can load the GUI, but you have to load the GPL separately, and they're separate products, but together they create something,
Yeah.
and you've got to go down that path.
Well, right. I mean, if you're using an open source compile, you can use that for closed code and not.
Right,
peg it,
just the
but
fact
if
that
it's
that's just so tightly commingled that it's
Yeah.
that it's not separate.
I think that's ironic out of here is that Broadcom's particularly bad for this, because there's so many different Wi-Fi drivers that Broadcom has released as closed binary blobs, literally as like objects that you would compile into your kernel module, and they somehow are able to keep it all separate. It's a bane of my work.
Yeah.
I mean, is that a difference in the US and Canada, or
Well,
what are your thoughts?
I mean, the license terms would probably be interpreted similarly in U.S. and Canada. In Canada, we have no lawsuits or court decisions to tell us how this would be treated. It's safe to say it would be interpreted in a similar way, and I don't think there's been any cases that interpret that particular question. So that's part of the problem here, is we're sort of having to grope our way forward in the dark a little bit, because we can sort of impose our interpretations onto how the GPL should be interpreted, but we don't know ultimately at the end of the day how a court will treat it. Okay, so the other example is BusyBox, which was, there seemed to be a sort of cottage industry in suing companies for BusyBox GPL violations. Most of which have settled. There was another round of them in December of last year, so a couple of months ago, where a number of big name consumer electronics companies were sued for having BusyBox software somewhere in their consumer electronics products, and it was a way to force compliance, and also to get them to appoint an open source compliance officer and maybe pay some money or rewrite the code, or all three.
Is any money changing hands, or is this at best just community service?
There is money changing hands, but it's a drop in the bucket. I mean, if you look at the sort of the legal fees that the Free Software Foundation incurs to fight this stuff, because they're the ones who sort of carry the standard of open source software and march into battle. They're really nominal.
Being lost by Best Buy not releasing some codec that's buried inside some TV.
That's right. It's more, and I think the average consumer isn't outraged that there are GPL violations. They're not sort of marching in front of Best Buy to demand compliance.
Until now.
This is a fun one. It's got attention because it's the first decision that's actually gone all the way up to the Court of Appeals in the Federal Circuit, and a decision that's come down on sort of the enforceability of an open source license, which had never been done before. And it had to do with this certain code that was released under open source license terms to control model trains. And if any of you are model train enthusiasts, maybe you know how this software works, and I haven't actually looked into it. But basically it was released under, it was written by, it's always written by a group, but Jacobson was sort of the lead guy. And it was released under this artistic license, which is a very vague and difficult to interpret open source license. And it wasn't the ideal license to use as a test case, but they used it anyway. This is what they had. And essentially, Katzer was the fellow who sells commercial software in connection with model hobby trains. And he apparently there was some of the code embedded in his software, and he didn't follow the terms of this artistic license, of the open source license. So there was a flurry of activity, nasty letters flying back and forth, the stuff that makes my heart go pit-a-pat. And so what happened was Katzer, interestingly, had a set of patents that he had applied for that covered model train software. So there are all kinds of interesting angles to this case. So copyright, as I say, Jacobson said he's the author and the owner of the copyright, the code, and so he's entitled to claim copyright ownership. And there was also the contract element of the open source license and whether that had been breached. There's the patent element, where Katzer said he had applied for several patents and said that Jacobson was infringing his patents. So yeah, you may have your open source software, but you're infringing my patents, so I'm going to sue you for patent infringement. And then there's a trademark element where Decoder Pro was the trademark under which the JMRI software had been released. And Katzer went around and quickly registered decoderpro.com just to sort of add a fun domain name element into it and trademark element. So it's a great way to sort of tie this back to where we started, with all the different categories of intellectual property rights. And essentially, because Katzer threatened Jacobson with patent infringement, Jacobson ran off to the court and said, I want a declaratory judgment. In other words, I want the court to give me a judgment saying I'm not infringing these patents. And that started a chain reaction of lawsuits and appeals that went up to the U.S. Court of Appeals, Federal Circuit twice. Actually went up, bounced back down to the district court, and then went back up to the federal court. In the end, there was a decision. It was actually a couple of years ago now, in 2008, that held in a way that open source. The take-home message is that open source licenses can be enforceable. And there are all kinds of finer points of law that were argued about copyright and how you, whether it's a copyright violation or a contract violation, and how those all fit together. But the short answer is that there was a decision that even though this wasn't a traditional license with royalty fees or license fees, that there's still an economic element and an economic benefit to the person who's releasing it, and they're entitled to have their license terms enforced in court. This is just a quote from the judgment that says, even though a fee isn't being charged, the value and the benefits that are being associated with the open source software are worth protecting, and the court will protect it. So that kind of brings us to a close in terms of the intellectual property elements that I wanted to sketch out in the open source world. Any other questions?
Working as a corporate minion during the day and a open source crusader during the night,
Right.
where the balance comes
Do you have a
with... I can wear my underpants on the outside. where the balance comes in, a personal responsibility. This is something I learn or find out at work. Problematic to use in free software during the night.
The idea of knowledge and expertise that you've gained through working, and whether you can then go home and create an original work, something completely separate from your employment, that's your own work, and you are entitled to do that. If you were creating software that was an exact replica of a product that was sort of the flagship product of your employer, that might be an issue. But even there was a case in Canada where there was a lead developer on the software program. He quit, walked across the street, got hired by the competitor, and rewrote the entire program. And the court said, well, if it's rewritten and it's original, then he owns that copyright in that new program. It's a new program. It's not a borrowed program. And the former employer complained and said, well, look at all these similarities. And the court said, well, those are functional similarities. So there's, as I said before, if you're creating a table and the table has rows and columns, that's a functional element of any table. So you can't claim that there's copyright protection. So of course there's going to be some similarities, but if you create something original, then you're entitled to that, and it won't be an infringement of any copyright of the former employer.
Agreements that people usually sign when they start a job.
Well, that's right. The non-compete is an interesting one. You certainly can be stopped from competing with your former employer under the terms of a non-compete. But non-competes are, put it this way, they can be tricky to enforce in real life, because they have to be very well drafted in order to be enforceable. I've seen lots of non-compete clauses that would never stand up if they got in front of a judge. So people are afraid to ever get in front of a judge because it's expensive and time-consuming. So they may abide by it just because they don't want to ever go there. But if you actually looked at the way the clause is drafted, it would just fall apart like a house of cards. The basic sort of proposition for non-competes is that they have to be reasonable in terms of their length of time and the geographical scope. So if you say, well, you can't compete against us, you're a key person and you're in charge of this project, you can't compete against us if you quit for 3 months within the city of Calgary, maybe that is enforceable. But if you say, well, you can't compete us anywhere in the world for the rest of your life, that's certainly not enforceable. Another thing you'll see is this sort of, you can't compete with us for 2 years, and if that's not long enough, then 1 year, and if that's, court doesn't like that, then 6 months. These sort of these, those things will never stand, just so you know.
What about if you're, at night going home and doing an open source program? At
They
the
will
same
fine
time, you're
you.
still employed?
Oh, for the same employer?
At the same time that you're,
Yeah, no, that's okay. I mean, you're entitled to go home and do something different than what you're doing during your day job. And- Well, that's right. I mean, you owe a duty of loyalty to your employer. So if what you're doing at night while you're wearing your cape is in direct competition with your employer, while you're employed, maybe you're offside that sort of duty of loyalty because you're actually harming your employer at night and then going back to work there during the day. But if it's a completely different project, you say, well, I've got my own deal here, my own project, my own thing that I'm working on, you're perfectly entitled to do that.
Yeah, isn't there a duty to the public as well? Like, isn't the public kind of involved, like a benefit to the public as a result of that work? Is that part of the consideration for the non-compete?
There's a public policy element to non-competition restrictions to work in favor of the employee, to say that people shouldn't be stopped from making a living. So you can't say, well, we're gonna fire you as an employee, and you have to sit at home and do nothing for a year because you can't work anywhere. Well, what that means is the person can't earn a living, and there's a sort of a public policy argument that judges will use to say, well, we're not going to enforce that. We're not going to uphold those restrictions. This person is entitled to earn a living, but they can't solicit customers of their former employer, or they can't poach trade secrets, or steal source code or whatever. So there is sort of a balancing act there. Yeah. Any other questions? Yeah.
why do you have a logo on all your slides?
I'm. Yeah. That's my firm. That's the firm I work for.
It's a fine example of trademark.
Creating brand awareness. Yeah. Any other? I think we're wrapped up for time. So thank you very much for your